We're starting this morning on page 9 of the corporation's outline, talking about piercing the corporate veil. But before we talk about piercing the corporate veil, we have to talk about one of the two characteristics of corporations that you absolutely have to know. And that is the principle that shareholders in a corporation are generally not personally liable for the debts of the corporation. That's why we invented corporations back 150 or so years ago, is so that people could invest in a business without having to risk personal liability for the debts of that business. And we created the corporation, which, as we will see in about a half an hour, separates the management of the business from the ownership of the business. And the owners are not personally liable for the debts of the business beyond what their investment in it is. So that is a statement you just have to commit to memory and will undoubtedly have to regurgitate somewhere on the exam. However, there is an exception to this principle that the shareholders are not personally liable for the debts of the corporation, and that's where we get to the piercing the corporate veil. There are rare and extraordinary circumstances under which courts will find, usually it's a single dominant shareholder, quite often the sole shareholder, when for equitable reasons we don't want to leave the liability solely on the corporation. We want to make that shareholder or a very small group of dominant shareholders personally liable when equity requires, when otherwise it would cause injustice or fraud. And there's a lot of different ways that the courts characterize this. But basically, it's when the corporation is a sham. And it really is nothing more than the business of the individuals being done under this shell corporate form. The thing you have to keep in mind, and you should always use the words rare and extraordinary when dealing with this, because courts are very reluctant to pierce the corporate veil unless it is such an obvious situation. And the reason is because we don't want to create an environment in which people are unwilling to invest in businesses because of fear of personal liability. So it's only in rare and extraordinary circumstances that courts will pierce the veil and make a shareholder or shareholders personally liable for the debts of the corporation. And the grounds that the courts look to in all the 70 exams or so that I've looked at, there's only been one, and I think it was back in 2004, where the exam specifically said, list the criteria or list the grounds that courts look to determine whether or not to pierce the veil. You're probably not going to have to just list them, but you have to understand the kinds of things that courts will look to. And what you will typically get is a question about a small corporation where there's one dominant shareholder, maybe a couple of other minority shareholders, and something happens, the corporation becomes liable for something, and the question says, is shareholder Sally personally liable for these debts? Can she be sued? And you have to start off with this memorized, generally shareholders are not personally liable for the debts of the corporation. However, in rare and extraordinary circumstances, a dominant shareholder or shareholders can be found to be liable for those debts if certain circumstances are there that would otherwise create fraud and injustice. And then you might want to indicate whether or not any of these circumstances are present. The most important of which is the third one. This outline probably has them flipped upside down in terms of order of importance. The most important one is whether or not the corporation is undercapitalized, which basically means that when the original stock was first issued to the sole or dominant shareholder, the amount of capital that shareholder paid for that initial stock was not sufficient to cover the expected startup costs and risks of the corporation's business. Somebody starts a dynamite blasting business to build highways and takes all of the stock in that company and pays $10 for it. Clearly, that's insufficient capitalization. And if the corporation or the company, the corporation, then becomes liable because of injuries that are caused, it won't have any money in the bank to pay for those injuries. The court would look to that and say, this is not reasonable, this is not fair, this really wasn't an independent business entity. It was grossly undercapitalized, and we're going to make this dominant or sole shareholder personally liable for those debts. And there are other factors that in the real world courts look to. Even if you're undercapitalized, if you go out and buy liability insurance, that will be considered as to whether or not you're undercapitalized. But that's the key, is undercapitalization. Thin capitalization there, little Roman numeral 4, is a slightly different but essentially the same concept as undercapitalization, and I don't think the bar exam is going to ask you to differentiate between those two. It's just simply whereas if the guy invests $1 million in getting the corporation started up, but he only counts 10 of it as capitalization and the other $999,990 as debt, he's over leveraged in the sense that what he has really invested is capitalization and not a debt. But it's a very similar concept, and all you have to know is that if you don't invest enough at the start to cover the expected costs and risks of the business, it will be undercapitalized, and that's probably the primary grounds for piercing the corporate veil. Also, if the assets of the corporation tend to be commingled, the little story I always use is if you're running a mom and pop grocery store that's incorporated, and little Johnny runs in after school and says, I need $5 to go buy a sandwich or an ice cream cone, and you reach into the cash register of the company and give little Johnny $5, you're commingling corporate assets with the personal lives of the shareholder. That's something that the courts will also look to. And also whether or not the business has been conducted in proper corporate form. The law requires that you have shareholder meetings and director meetings and keep minutes of the meetings, and et cetera, et cetera. So if you don't follow those procedures that a real functioning independent corporation is supposed to follow, that too will be considered in deciding whether to pierce the corporate veil. Corporate purposes and powers. We've already mentioned back when we talked about the articles that one of the mandatory statements in the articles is what is the corporate purpose. And generally it can be, is a very broadly worded, a very common typical one is the purpose of the corporation is to engage in any lawful activity for profit. That is a very common statement of purpose. If in order to get minority investors to invest in the company, you've got to somehow limit that. Maybe you go to somebody and say, I want you to, take a third interest in the company. Will you invest in it? And they'll say, well, what's the business going to be? And if you say, well, we're going to open a bicycle shop because there's a great need for it, you might insist, the minority investors might insist that the articles state that the corporate purpose is to operate only a bicycle shop because they don't want you taking their money and going and running an ice cream store, which they think would be a bad investment. So you can limit the corporate purposes, but whatever your purpose is, whether it's broad, any lawful activity for profit, or whether it's more narrowly defined, you have to state the corporate purpose. Now, if you do state the corporate purpose as something narrow, then obviously the corporation, i.e. its board of directors, should not operate that business beyond the scope of those purposes. But as long as they limit the activity of the corporation to something that is arguably furthering the purposes as stated, they then have the power to perform any acts which are, quote, necessary or proper to accomplish those purposes. If they do engage in activities that are beyond those powers, if they open up an ice cream store and they're supposed to be running a bicycle shop, we say that the corporation is acting ultra vires. The board of directors is clearly going beyond the scope of their authorization. And indeed, that's a term that is used whenever the board functioning as the corporation, or an individual, whether it's an individual partner, whether it's a member of a limited liability company, whether it's a corporate director or officer, anytime somebody does something that exceeds their lawful authorization, we say they're acting ultra vires. And in the case of a corporation itself, if the corporation is starting to do things that clearly exceed the stated purposes of the corporation, we say they're acting ultra vires. However, this is something that is really not easily remedied. The only things that can be done if the corporation starts to act ultra vires is somebody can file a lawsuit. It would probably be one of the shareholders, would go into court to seek an injunction to stop the corporation from committing ultra vires acts or to prevent it from committing future ultra vires acts. Or if the ultra vires acts results in damage or loss to the corporation, then again a shareholder could come in and in a shareholder derivative suit, which we'll talk more about later, and sue to recover those damages. So board members who voted for the ultra vires acts would then become personally liable because they've exceeded the scope of their authority and have breached their fiduciary duty to the corporation, which we will talk about in just a second. But those are the two remedies for an ultra vires act. Those agency principles, I'm not going to spend a lot of time going through them. I'm sure you all have covered agency principles in law school. There are three ways in which a corporation can become liable for transactions or conduct engaged in on behalf of the corporation. One is if the human being who engaged in that activity had the actual authority to act for the corporation in that way. An actual authority can come either because it is expressly granted to the individual or because it is implicit in the nature of their job. If the president of a company goes out and buys office supplies, there may not be a board resolution giving the president the authority to buy office supplies, but implicit, inherent in the nature of his job is the authority to buy office supplies. So either express or implied authority is actual authority, and the corporation is, of course, bound, just as a partnership is bound by a partner who does something within his mandatory authority. On the other hand, sometimes, as we talked about in the partnership context, same thing is true in the corporate context, an individual can go out and bind the corporation or enter into a transaction on behalf of the corporation when they actually don't have the authority to do that. But if the third party reasonably believes they have the authority to do that, the corporation will still be bound to the third party by apparent authority. And finally, even if the third party did not reasonably believe that the person with whom they were dealing had the actual authority, the corporation could still become personally liable on that transaction if it ratifies it, either by an express ratification by the board of directors or by accepting the benefit of the bargain, moving into the building or using the office supplies or whatever that implicitly accepts the corporation's responsibility for that transaction. Okay, there's been very little over the years about ultra vires and actual and apparent authority and that, but you should be familiar with those concepts because they sometimes become part of a larger question that you need to answer. Board of directors and officers. This stuff is very, very frequently tested. So it is trivial, it is nitpicky. Asking a lot of questions about this stuff is really kind of silly, but nonetheless, it is common to find a lot of questions on the bar exam about these relatively trivial matters. Board of directors. You only need one. That's the first thing you need to know. You don't need to have a real board, which kind of implies more than one person, kind of implies a group. You don't have to have a group. You can have a board of directors that has one person. The directors or director are usually named in the initial report. But if you choose to start the corporation with shareholders who then elect the first board of directors, you file a supplemental report. We talked about that yesterday. But either way, you start out with directors. And the second principle that you have to remember the first one I said you absolutely have to remember is that generally shareholders are not personally liable for the debts of the corporation. That's a little voice should be speaking to you when you sleep at night saying that. The other thing that you should remember is that management is separated from ownership in a corporation. That's the whole notion of what a corporation is. It's why the shareholders are not personally liable, because the corporate powers are vested in, and the business affairs of the corporation are managed by the board, not by the owners, i.e. the shareholders. The board runs the company, not the shareholders, which is why the shareholders aren't liable. And so that is the other memorized statement that you have to be prepared to just spit back on the exam. The corporate powers are vested in and the business affairs are managed by the board of directors. Another point that is frequently tested is that the board of directors functions like a legislature. If you're a director wearing your director's hat, you do not have the authority to act with third parties on behalf of the corporation. Directors do not have agency authority to act for the corporation. Only the officers and employees of the corporation have authority to deal with third parties. So you've got three different groups of folks in the corporation context. You got the shareholders who own the company, you got the board of directors who manage the company as a board, and then you've got the officers and employees who actually carry out the business of the corporation and have the authority to deal with third parties. Keep those three functions very separate. It doesn't mean that the same human being can't wear all three hats, because in small businesses they usually do. There's probably, in most hypos you're going to get in the bar exam, there'll be a corporation with maybe 3 shareholders, all of whom, or at least 2 of whom, are on the board of directors, and all of whom are officers in the corporation. But you have to keep straight when they're functioning in which capacity. There are certain things they can and can't do as shareholders, certain things they can and can't do as directors, and certain things they can and can't do as officers. There are no limits on who can be a director, but you can put limits on them in the articles of the bylaws. If the articles and or bylaws are silent as to any qualifications, then any competent person may be a director. And keep in mind that competence means legal competence. There's a lot of us incompetent people running around who are legally okay to be directors. What we're talking about is if you're crazy and certifiable. So any legally competent person may be a director unless the articles or bylaws say otherwise. A director is elected by the shareholders if there is no statement in the articles or bylaws otherwise. Then the default rule is that you're elected for a 1-year term. 1-year term is the default rule. Now you can change that, and quite commonly corporations in their bylaws or articles, either one, doesn't have to be in the articles, could be in the bylaws as well, can change that so that a director's term can be for as much as 5 years. You cannot have director terms longer than 5 years. If you want to have director terms for more than 1 year, it is advisable that they be staggered terms. Now, obviously, if you only have one director, you can't stagger the terms because there's only one director. But if you, let's say, have 3 directors and their terms are 3 years or 4 years or 5 years, you only want one to come up for election in any given year. You don't have to, though. Louisiana is, again, unique. Most states, if not all other states, require that if you have directors, if you have more than one director, you have to have at least one of them come up for election every year. And the reason for that is so that you have to have a shareholder meeting every year. Louisiana does not require that. You could have 3 directors with 5-year terms, all of whom come up for election at the same time. So you go 4 straight years without having a director election. So that's something that is, as I said, unique to Louisiana, and I don't know that it's ever been tested as such, but you should be aware that that is an unusual little twist in the Louisiana statute. Directors cease to be directors if they die, okay, or they resign, or one of a group of things, 4 things happen to allow the other board members to declare your seat vacant. But the typical and the key point here to note is that the board cannot expel one of its own members. Board members who are elected by the shareholders cannot be booted off by the other directors. The other directors can declare a seat vacant, which is kind of the same as booting somebody off, but not quite. They can declare a seat vacant if a director is adjudicated as bankrupt, if a director is interdicted or adjudicated to be incompetent, if a director becomes incapacitated by illness or infirmity for a period of 6 months or longer, or if a director ceases to have qualifications stated in the articles or bylaws. So you could have a small business that requires that in order to be a director, you have to be a resident of Louisiana. Or you could even have saying that you have to be a member of such and such a family. And if you get divorced and you're no longer a member of that family, they can declare the seat vacant. Or if you move out of state and the articles say that you've got to be a resident of Louisiana, they can declare the seat vacant. The only other way that a director's seat becomes vacant, other than with the term expiring, of course, so death, resignation, term expires, seat is declared vacant because of one of these 4 things. The only other way of getting rid of a director is through the process of removal. The shareholders may remove a director or directors with or without cause. Important to remember that. Remember back when we were talking about partnerships, a partner can be expelled by a majority vote of the partnership, but only with just cause. There has to be a good business-related reason. Removing a director by the shareholders does not require any particular cause. You can remove a director because he's ugly, even though that has nothing to do with the business of the corporation. The way that the shareholders can remove a director is by a vote of a majority of the total voting power, not just a majority of those voting or those attending a meeting, but a majority of all of the shares eligible to vote. So if there's 1,000 shares of stock in this corporation, 501 of them have to vote to remove the director. And they do so at a special meeting called for the purpose of considering the removal of that director or directors. So the power to call a special meeting is important. And we'll talk about who can call special meetings. But the process is you call a special meeting, you give notice to all the shareholders saying we're going to have a meeting on such and such a date, and the agenda item to consider is, shall we remove Director X? And then 501, or a majority of the shares, have to vote at that special meeting in favor of removal. Regardless of how many show up, you have to have a majority of the total voting power. If you have a corporation where different directors are elected by different classes of stock, which is unlikely to be on the exam, but just in case, then to remove a director, it requires a majority vote of that class of stock, as opposed to a majority of all the stock. So if you've got a subgroup of stock that elects a particular director, then only that subgroup can remove that director. And if you're elected by cumulative voting, again, I doubt this will be asked, but if you happen to get it, you can remove a director by cumulative voting with a majority vote of all the shares, just like any other situation. But, and we'll talk more about cumulative voting a little bit later, if enough people vote against removal who would have had the ability to elect that director in the first place, then the removal is not effective. Even if a majority of the shares vote to remove, if enough people vote no under a system of cumulative voting so that they could have elected that director in the first place, then the director is not removed. There's a little note there that, again, I don't think will be asked, but you never know. Because you can remove directors without cause, it is not clear whether you have to give the director whose removal is being considered notice and an opportunity to defend herself. In most instances, there has to be at least a stated reason why you want to remove the director. Doesn't have to be, but invariably there's some reason for doing it. Whether it makes any sense related to the business or not, there has to be some reason why you're considering removal. And most states do require that before a director is removed, that they be given notice of the purported reason for considering the removal and giving the director an opportunity to defend herself. Louisiana law is not clear on this, which is one of the reasons I don't think it'll be asked. But just in case it is, you should know that in most states that have a rule on this, notice and an opportunity to be heard is generally required. So, for what it's worth. All right, we now have a vacant position on the board. Somebody's died, resigned, their term has expired. Well, their term's expired is a separate issue. They've died, they've resigned, their seat's been declared vacant because they're bankrupt or incompetent or sick or no longer have the qualifications, or they've been removed by the shareholders. How do we fill that vacancy? Well, either of two methods, whichever one comes first. A board vacancy can be filled for the remainder of the vacant term by a majority vote of the remaining directors. And that is true even if the remaining directors do not constitute a quorum. So if you've got let's say a 5-person board of directors, and 3 of them go down in a plane, there's only 2 left. That's not enough to constitute a quorum of the board. But the 2 remaining can get together and fill those 3 vacancies because there's not a quorum. That's the only way they can act. Now, if there's 5 directors and 2 go down in a plane, then you've got to get through the normal process. All 3 of the remaining can have a meeting because they would constitute a quorum. So just 2 of them getting together and filling the vacancy wouldn't count because you got to have a quorum in order to have a meeting if there are still 3 directors remaining. But it's that peculiar situation where if enough people are removed so there's less than a quorum left, then the less than a quorum can get together and fill those vacancies. The other way of filling a board vacancy is by a majority vote of the shareholders at a special meeting. Now, what this typically means is since whichever one of these things happens first, if a majority of the remaining directors votes to fill the seat on Thursday and a majority of the shareholders meet at a special meeting on Friday, the directors appointed by the remaining directors win because that happened first. So whichever happens first is the effective action. And what it typically means is that if the shareholders remove a director, then a majority vote of the shareholders will fill the vacancy, because at the special meeting called to remove the director, there will also have been notice given of a special meeting called at the same time for purposes of filling the seat should the director be removed. So the shareholders will be right there when they remove the director, so they might as well vote to fill the vacancy. But if a director dies or resigns or their seat is declared vacant, the board will be in a much more efficient position to fill those seats. So depending on why the vacancy occurs will pretty much determine which method is used to fill the vacancy. But on the bar exam, you would have to know that either the remaining directors by majority vote or the shareholders at a special meeting by majority vote can fill the vacancy. Board action. You talk about trivia, but this stuff is invariably on the bar exam. And I've had some former students who've taken the bar exam in the last few years tell me this stuff is in the multiple choice questions. So you should learn it. You can forget it 30 seconds after the bar exam's over, but for the bar exam, remember it. How does the board act? Well, the board, with one exception we'll talk about in a minute, may only act at a regular or special meeting called with adequate notice to each director. So directors have to act at a meeting. In order to vote, a director must be present at the meeting. The general rule of corporate law everywhere is that directors may not give their vote in a proxy. The director has to be the one to cast the vote. So the director has to show up at the meeting and must cast the vote. You can't give your proxy to your next door neighbor or your spouse or your kid and say, you go to the meeting for me and vote. You have to be there and you have to cast the vote. There is an exception, and Louisiana, I believe, is unique in allowing for this. If the articles of the corporation allow it, so if the articles are silent, then there's no exception. If the articles are silent, directors cannot give a proxy to anybody, period, end of discussion. But if the articles allow it, a director may give her proxy to another director or to a shareholder. Last time that question was asked, I believe, was in February of 2008 and in July of 2009. Those are the 2 times I know that question has been asked about, can a director give a proxy to somebody? And the answer is no, unless there's a clause in the articles allowing for it, and then only to another director or a shareholder. Now, what do we mean by the word meeting? Do the directors have to appear in person in the same room? And the answer is no. The board may meet by telephone conference. in which all of the directors can simultaneously hear each other. And it's hearing each other, so when one speaks, all of them have to be able to hear it. You cannot have, and this was a question of several years ago, where the director gets, or the chairman of the board gets on the line and there's like 4 different phone lines to separate directors. So the chairman of the board can hear everybody, but they can't hear each other. That's not a teleconference meeting. It has to be where all of them can hear each other whenever any of them speaks. And if everybody can hear everybody else, that is a valid meeting. They don't physically have to be in the same place. They simply have to be able to hear each other at the same time. The articles, bylaws, or the board itself by resolution may delegate some of the powers of the board to subcommittees or committees of the board, which is made up of some subgroup of the directors. When such powers are delegated to such committee, then the rules that would normally govern the board govern the committee. They can have a telephone conference call, but they cannot act without having a meeting, and the directors or the members of the committee actually have to be the ones present and casting the votes. So if you create these committees, they then function with respect to those delegated powers just as if they were the full board. The one exception to the requirement that board action be taken at a meeting is that the board may act by unanimous written consent. The key words there are unanimous and written. If you're a large corporation and you have 25 directors and 24 of them sign a resolution, and one of them is, on safari in Africa or climbing Mount Everest, it is not effective. 24 out of 25 doesn't do it. You got to have unanimous consent, and it must be in writing. The chairman of the board can't pick up the phone and call each of the directors and get their oral consent. It has to be signed writing. And that is often asked. I would say probably half the exams will have a question about, can the board act at other than a meeting? And the answer is yes, but only with unanimous written consent. Quorum requirements. I'm told there was a multiple choice question on the last exam about board quorum requirements. So you should know it. To have a quorum, there must be a majority of the members of the board present at the beginning of a meeting. Makes sense. Not hard to remember. But what is kind of interesting is that once a meeting starts with a quorum, that meeting can continue even if some of the directors leave and there's less than a quorum remaining. So if you have, let's say, 9 directors and 7 of them show up for the meeting, or 5 show up for the meeting, you've got a quorum. A majority is there. But then halfway through the meeting, for whatever reason, some of the directors say they've got a tea time or they're sick and have to leave, and there's only 4 left. Can the meeting continue with less than a quorum? The answer is yes, it can. Once the meeting starts, it can continue until it's adjourned. However, if less than a quorum are present, the board can only take action if the number of people voting in favor of that action is at least a majority of the quorum. So if you've got a 9-person board, 5 show up, meeting starts, 2 of them leave. There's only 3 left. Can those 3 take action? Yes. If all 3 of them vote for something, 3 is a majority of the quorum, which is 5. However, if the 3 remaining split their votes and it's 2-1 in favor of something, a majority of the directors there have voted in favor of something, but it does not pass because 2 is not a majority of the quorum. Isn't this exciting stuff? I mean, this is really, really great stuff. Anyway, the statute provides for that. So you can continue a meeting with less than a quorum, but you can't take action unless a majority of the quorum votes in favor of it. Except for that bizarre and unusual circumstance, generally, in order for the board to act, there must be a majority vote of those directors present. That's important to understand the subtle aspect there. It's a majority vote of those present, which basically means that an abstention is a no vote. Because if you're present, you're counted in the denominator. So if you have 6 directors present, you take a vote, and the vote is 3-2 with 1 abstaining, it does not pass. Because 3 is not a majority of the 6 who are present, even though only 2 voted against. So you be very careful about these voting requirements. A majority of those present is different than a majority of those voting. And quorum and voting requirements may be modified by the articles or in the bylaws, but that's never asked in the bar exam, so I just throw that in as a footnote. If the board declares that something has passed when it hasn't, and they later discover that it was improperly declared by the chairman to have been passed, that action may subsequently be voidable, but not necessarily. The board at a subsequent meeting can ratify the earlier action, which makes it retroactive back to the date that it was originally, but wrongly, adopted. So if, on April 1st, April Fool's Day, the board chairman wrongfully declares that a policy has been adopted, and it turns out that there really wasn't an adequate vote, or the meeting was improper, or whatever, at a meeting of the board on June 1st, the board can ratify that decision with a proper vote, making it retroactive back to the April 1st date when it was improperly declared. And of course, there is a person who is the chair of the board, presides at the board meetings. The chairman has the same single vote as all the other members of the board, and only 1 vote. The chair cannot break a tie if the chair has already voted. Okay, let's take a 10-minute break. Seems like it's a good place to do so. Be back right at the top of the hour. Okay, we're picking up page 13. Duties and liabilities of directors. This is a topic that has become increasingly tested. I think Mr. White is more interested in ethics and conflicts of interest and duties that board members owe than previous examiners have been. So this is an important subject. And indeed, if you look at the February exam just a few months ago, all of Part 2, well, 4 of the 5 parts of Part 2, deal with these issues of when is an officer liable, when is a director liable, when do they breach their duties, what are those duties. You should really look at those questions and the model answers to those questions carefully because I think they give you an insight into the kinds of things that White is interested in here. But the general rule, again, is that directors and officers of a corporation are not personally liable for the debts of the corporation, just like shareholders. But like shareholders, where there is this rare and extraordinary exception where they pierce the veil, there are also exceptions for directors and officers, where they can become liable if they fail to meet their fiduciary duties to the corporation. So what are those duties? Well, there are 2 generic categories of duties. One is a duty of reasonable care, and the other is a duty of loyalty. Now remember, in the partnership context, the only duty that partners owe to the partnership is the duty of loyalty, not the duty of care. But directors and officers of a corporation owe both, the duty of care and loyalty, which includes a duty to stay informed and make reasonable inquiry whenever there's an issue before the board. It is a just general principle that the core duty of the director or an officer is always to act in the best interest of the corporation as they reasonably believe it to be, putting the corporation's interests above their own personal interests with respect to the matters relating to the business of the corporation. Okay, how does that apply to the duty of care? Well, the duty of care is not a typical tort standard whereby you become liable if you are negligent. There was an old case back in 1999 where the First Circuit Court of Appeals over in Lafayette ruled that directors could become liable if they were simply negligent in making decisions. And this created a huge furor. And so the legislature passed an amendment to the corporate statute that now makes it clear that a director or an officer does not breach the duty of care unless they act in a manner that is grossly negligent. In other words, you have to do something really dumb as opposed to just a little dumb. And the reason, of course, is because we want people to be willing to become directors. And we don't want to subject them to the kinds of lawsuits that we see in tort cases where every time something happens, somebody claims that there was somebody who was negligent. And that would subject directors and officers to constant litigation every time a business decision doesn't turn out the way they hoped it would. We want directors and officers to be able to take reasonable risks and not have to worry about getting sued. But if what they do constitutes gross negligence, which is up to a jury to decide when it does, then they can be held personally liable. And that is consistent. The gross negligence standard is consistent with the general principle of what we call the business judgment rule. Courts will defer to the reasonable business judgments of the directors and officers of a corporation without second guessing them. Again, allowing them to take reasonable risks. But one of the things that can constitute gross negligence is if directors act without obtaining what a reasonable person would consider to be the necessary information. So you not only have to vote in a responsible way, but you also have to properly inform yourself of the relevant information that would determine how you might vote. And then, of course, you have to vote in a manner that you believe to be in the best interest of the corporation. If we're talking about the duty of care, the corporation has various ways of protecting its directors and officers from becoming liable for a breach of the duty of care. And that's what's in number 3 down there at the bottom of page 13. The first is in Article 24C4 of the statute. It provides that the articles, and this is one of those things that has to be in the articles. It cannot be in the bylaws or anywhere else. Has to be in the articles. But the articles may contain a provision that eliminates or limits the liability that any director or officer, but usually director, may have to the corporation for a breach of the duty of care. This cannot protect an officer from or a director or an officer from liability for breach of the duty of loyalty, which we'll talk about in a second. We don't want to allow corporations to give their directors and officers carte blanche to act deliberately against the interests of the corporation. So we do not allow them to limit their liability in any way for a breach of the duty of loyalty. But if the shareholders of the corporation are willing, they can put in the articles a provision that basically gives directors and officers carte blanche to act grossly negligent. So that's one thing they can do. Secondly, the board itself don't need shareholder approval. It doesn't have to be in the articles or even the bylaws. The board can vote to indemnify or insure any director, officer, or agent involved in any proceeding for conduct engaged in on behalf of the corporation in good faith. It is a rare corporation, and indeed one populated by dummies, where the board doesn't do this. Why wouldn't you, if you're a member of a board of directors, vote to indemnify yourself? What person would not cover their rear end in that way? So it is just routine that boards of directors of every corporation vote to acquire director and officer insurance and pass a provision creating indemnity. But they have to take that affirmative action. They almost always do, but they have to take that action. So the articles can have a provision. The board can indemnify or insure officers and directors. And then the third thing you have to remember is that the statute itself in Section 83B provides that if a director, officer, or agent is sued for acts undertaken on behalf of the corporation and is successful in the defense of that suit, then they must have all of their litigation expenses, including attorney's fees, reimbursed by the corporation. They have to have. The statute requires it. Remember when we were talking about partnerships, we had a little paragraph in the partnership outline saying partners do not get automatically reimbursed under the partnership law, although mandate law may provide for it. The corporate statute has an express provision providing for that. Okay, duty of loyalty. The duty of loyalty, again, the basic principle is that you have to vote and act in a manner that's in the best interest of the corporation as you reasonably believe it, and not as is in your best interest. One of the principles that grows out of that generic rule is that any transaction entered into by the board of directors where one of the directors on the board has a conflict of interest is presumptively tainted and subject to being voided subsequently, unless, so there are ways to sanitize these presumptively voidable transactions. And what that means by presumptively voidable is that the burden of proof is on the board to show that the transaction was not harmful to the corporation, that it was in the best interest of the corporation, whereas normally the burden of proof would be on a plaintiff seeking to rescind the transaction because of the presumptive taint. If there is a conflict of interest with one board member, then the burden of proof shifts to the board to justify the transaction. Now, how can we sanitize it? How can we shift that presumption back to the plaintiff? Well, the answer is, first, if the director who has a conflict of interest makes full disclosure to the board, and then a vote of the disinterested directors, by a majority of the disinterested directors, ratifies it. So if you've got, let's say, a five-person board, and they're proposing to buy an office building, and the office building happens to be owned currently by one of the board members, clearly there is a conflict of interest. If the office building is owned presumably by a board member's spouse, or by a corporation in which a board member has a shareholder interest. If a board member has an interest, a significant interest in the transaction, then there is a conflict of interest. Okay, the resolution to purchase that piece of property goes to the five-person board of directors. They vote 3-2 in favor of the purchase, with the interested director being one of the three. Resolution passes. Corporation could go forward and buy that piece of real estate, but it hasn't been sanitized because you did not get a majority of the disinterested directors voting in favor of it. The disinterested directors split their votes 2-2. So you didn't get that first way of shifting the presumption back. So this continues then to be a presumptively tainted transaction. So is there another way that we might sanitize it? Well, yes, if we make full disclosure of the conflict to the shareholders. And a majority of the shares, not a majority of the shareholders, a majority of the shares vote to ratify the action. You'll notice it does not say a majority of the disinterested shares. In this case, the board member who has the conflict of interest may vote his or her shares and have that count towards the sanitization process. So to get a majority of the board to sanitize it, it's a majority of the disinterested directors. To get the shareholders to sanitize it, it's simply a majority of all the shares, including the conflicted shares. And if you can't get either of those, majority of the disinterested directors or a majority of the shares, then the third way that the transaction will ultimately be approved is if it is determined to be fair to the corporation. But of course, who's going to determine that? And the answer is it's going to have to be determined by a court after somebody brings a lawsuit. And if neither of the first two methods has sanitized it, then the burden is going to be on the board to prove that the transaction was fair to the corporation. Another way that you can breach the duty of loyalty is for a director or an officer to take an asset of the corporation for his own personal benefit. This is the same as the fiduciary duty that partners have. We talked about it back in the partnership context. You may not take an asset that belongs to the corporation for your own personal benefit. And that includes, and the bar exam invariably tests on a prospective business opportunity. So if you're a director or an officer of a corporation that is in the plumbing business, and somebody calls you and says, I've got a leaky pipe, will you come and fix it? You cannot go and fix that pipe and take the payment for yourself. That is a customer of the corporation, and the proceeds have to go back to the corporation. They cannot go to you personally. Now, there was a question several years ago where it was an issue as to whether or not the business opportunity was related to the business of the corporation. If you're a director or an officer in a plumbing business corporation and somebody calls you and asks you to give them a golf lesson, you're free to do that because it is not something that is within the scope of business of the plumbing corporation. But anything that's even remotely within the scope of what the corporation does, you can't take it without giving that opportunity to the board first. Now, if you take a prospective client or a prospective customer to the board and they say, we don't want to have anything to do with it, that's too big a project, or we don't want to work for that guy or whatever, and they reject the opportunity, then you can take it for yourself because the corporation has turned down the opportunity and it's no longer an asset of the corporation. If you do take a business opportunity that rightfully belonged to the corporation, then the remedy to the corporation is that any of the proceeds that you earned or any of the financial gain that you got from taking that asset is that you hold those proceeds in a constructive trust that as soon as possible has to be turned over to the corporation. If a director is faced with an issue at a board meeting as to whether or not to do something or buy something or undertake some project, and you believe that it is not in the best interest of the corporation, and you think that if the corporation does this, it could result in liability, that it's grossly negligent for the board to do this, then you want to protect yourself. And the general rule is that a director is not liable for any unlawful acts, obviously, if they were absent from the meeting at which the act was authorized. But if you are present at the meeting, then you have to be sure that your dissent is clear. Now, if your dissent is in the minutes, you're home free, but you don't keep the minutes. So just to make absolutely sure that there is a record of your dissenting to the action, you should write a letter to the corporate secretary saying, remember, I dissented at the board meeting from this action, so that there is a written record of your not voting in favor of an action that you deem to be improper or illegal in some way or form. There's the statute of limitation. There was one question a long time ago, so we put this in the outline. If a shareholder or somebody else wants to sue a director or officer for a breach of the duty of care, there's a 1-year statute of limitation. A breach of the duty of loyalty, it's a 2-year statute of limitation. What can directors not do by themselves, or can the board not do by itself? And number 8 down there says, directors do not have the power by itself to amend the articles, to dissolve the corporation, to liquidate the assets of the corporation. The statute says to sell all or substantially all the corporation's assets, or to merge with another entity, unless the other entity is already 90% owned by the first corporation. So basically, the board can vote to merge with an almost wholly owned subsidiary without shareholder approval. But otherwise, mergers, liquidations, dissolution, and article amendments, the board cannot do those things by itself. And the way those things get accomplished is that they must be proposed to the shareholders, and then the shareholders have to vote, and we'll talk about what the vote standard is in just a sec. So there's a two-step process in amending, liquidating, merging, or dissolving. One, it has to be proposed to the shareholders, and then two, the shareholders have to vote to approve it. Now, liquidation of the assets and mergers can only be proposed by the board of directors. And the reason is because that's not a yes or no kind of thing. If you're going to liquidate your assets, you have to find a buyer and you have to have a deal that the shareholders can vote to approve. And the only way you can have a deal is to have somebody negotiate it. And that's what the duty of the board is to make sure that you've got a deal that is in the interest of the corporation. Likewise, a merger requires negotiations with the other company. So only the board can enter into those kinds of negotiations that would lead to a proposal for liquidation or a proposal for a merger. Amending the articles or dissolving the corporation don't require any third-party negotiations. They can just be proposed, up or down vote with the shareholders. So for those, you don't have to have the board proposing them. The board can propose them, but anyone who can call a special meeting of the shareholders can propose an articles amendment or a dissolution. Which means, as we will see, that a group of shareholders holding 20% of the shares of the corporation can sign a petition calling for a special meeting. The president of the company can call a special meeting, or the board of directors can call a special meeting. So the board, 20% of the shares, or the president can propose an amendment to the articles or a dissolution. Then it goes to a shareholder meeting, and for article amendments, liquidations, and mergers, the shareholders can approve those with 2/3 of the shareholder voting power present. Remember, to remove a director required a majority of the total voting power. So even shares that aren't at the meeting are part of the denominator in that case. Here, it's 2/3, it's a higher percentage, but it's only of those shares present at the meeting. For dissolution, it's only a majority of those present at the meeting. Now, those voting percentages can be altered by your articles, but they never are, and they're never tested. So you just have to remember what the default rule is. For amendments, liquidations, and mergers, it's 2/3 of the shareholders present. For dissolution, it's a majority of the shares present. Payment of dividends. This is a commonly asked question. The details of the limitations on how much can be paid out in dividends are never asked. But there is a general principle that frequently gets asked. The whole notion is that we have to impose some limits on the board of directors on the paying of dividends. Now, if the board does not want to pay dividends, there is essentially, for all practical purposes, no limitation on the board in making a decision not to pay a dividend. Now, there are some exceptions to that. I remember back in the 20s, Henry Ford was actually found to have violated his duty to the corporation because instead of paying dividends, he was taking the money and subsidizing below-cost cars because he said every American has the right to own a car, so I'm willing to, instead of giving my shareholders dividends, I'm willing to invest that money in making sure every American has a car. Well, the court said that's not a valid use of corporate funds. The shareholders have a right to expect you to try and maximize the profits. But if the board has any plausible justification for not paying a dividend, the courts will defer to that judgment. So the board can always not pay a dividend unless it's just stupid and does it for the wrong reasons. On the other hand, if the board wants to pay a dividend, we have to impose some restrictions. Now, why do we have to impose some restrictions? Well, the answer is because the shareholders aren't personally liable for the debts of the corporation. So if the board could take all of the assets of the corporation and distribute them to the shareholders in the form of dividends, you could screw the creditors, because the corporation then would be left with no assets, and the creditors would come and try to collect on the debt that the corporation owes them, and lo and behold, all the assets have been given to the shareholders. So we have to impose limits on the ability of the corporation to give those assets to the shareholders in the form of dividends. There are some very complicated rules about when dividends can and cannot be paid out, and you will not be asked those complicated rules. They all deal with some strange accounting mechanisms called capital surplus and stated capital and earned surplus. And it really does get very complicated. I don't think the bar examiner understands them, so it's probably not going to be on any bar exam. It never has been in the 70 exams I've looked at. But you do have to know the basic principle that a board may never pay a dividend if, after the dividend is paid, the corporation would be rendered insolvent. And what that basically means is the corporation able to pay its debts as they come due in the usual course of its business? So if you look at the outstanding debts of the corporation, they may not distribute more cash to the shareholders in the form of dividends if the cash that would be left afterwards is insufficient to pay those debts as they come due. And there's no easy, simple formula for determining that, but if there's a question as to whether or not the corporation is in fact insolvent, that would end up in front of a court. And a court would have to look at what are the debts of the corporation, when do they have to be paid, and what is the cash position of the corporation. And the bar exam, when it asks this question, will always give you a situation in which it's pretty clear that the corporation would be insolvent. So you have to remember that basic principle. And the concept of you can't pay dividends under these conditions of insolvency do not apply to stock dividends, which was asked one time a few years back. A stock dividend is not distributing assets to the shareholders, it's just distributing more stock to the shareholders. So all you're doing is basically splitting stock into more but smaller equity shares. What happens if the directors do pay an unlawful dividend? Well, the directors who vote in favor of it will be liable to the corporation or to the creditors of the corporation if they should bring a lawsuit to recover from the corporation and their insufficient assets. Then the creditors can go back against those directors who paid the unlawful dividend. There's an exception if you had an accountant who gave you bum information about how much the assets of the corporation were and what the debts were, but as long as you didn't have that kind of bum information, you will be liable to the corporation for the payment of an unlawful dividend. However, if a director gets sued personally, this is a breach of the duty of loyalty basically, and is personally liable for those illegal dividends, then those directors can turn around and try and recover the dividends unlawfully paid from the shareholders. So that ultimately the shareholders will be liable to repay any illegal dividends they received. Louisiana is the only state in the United States where the shareholders are liable for any illegally received dividends, even if they did not know they were improperly paid. In every other state, the rule is that shareholders who receive a dividend that they knew shouldn't have been paid have to pay it back. But that innocent shareholders, people who really were outside of the management of the company, who just got a check in the mail, had no reason to believe that those dividends were improperly paid, they don't have to pay it back. In Louisiana, they do. So if you're a shareholder of a Louisiana corporation and you get a dividend check in the mail, don't run to the mall and spend it right away, because you may end up having to pay it back. Unique to Louisiana. So the directors are personally liable, but they can then recover from the shareholders who received the improper dividend. What are dividend guarantees? Sometimes a corporation, and again, this has never been asked because the hypos on the bar exam are always fairly simple, 3-person, 4-person, where there's only a very limited number of shareholders and there's only one class of stock. But again, if you want, you can have a corporation where some of the stockholders have dividend preferences, so that the holders of preferred stock get $5 every year in dividends before the other shareholders, the common stock shareholders, receive any dividends. So you've got a $5 a year guarantee. And the question is that guarantee cumulative or non-cumulative? And basically what that means is if in any given year you don't get your $5, if you lose it, it's non-cumulative. If what you don't get paid gets carried over to the next year, it's cumulative. So if in year one you're supposed to get $5 a share, but you only get $3 a share, or you don't get anything, what are you entitled to the next year? If it's cumulative, you're entitled to $5 plus whatever you didn't get the year before the common shareholders get anything. If it's non-cumulative, you only get $5. It's $5 every year, regardless of whether you get it or not. That's the difference between cumulative or non-cumulative. If the articles are silent on this issue, then dividend preferences are non-cumulative. You're only entitled to the guarantee, which is not really a guarantee then. You're only entitled to the first $5, but it doesn't, if you don't get your full $5, you lose it. Unclaimed dividends, again, this is not a question that I can remember being asked, at least in modern memory, but you should have in your articles a statement that the corporation retains the right to retain any dividends that are not claimed by a shareholder. If you've got a shareholder who you don't know where they live, you don't know how to get in touch with them, you send out notices as best you can in the paper and what have you that there are dividends available and they go unclaimed, you want a provision in your articles that say the corporation retains the right to keep those dividends in the corporation. Otherwise, they become the assets of the state, and you don't want to lose them. But that's the rule for unclaimed dividends. As I said, it's never been asked. Redemption or repurchase of shares. This is a concept where instead of sending money to the shareholders in the form of dividends, the corporation sends money to the shareholders in exchange for taking back some of the shareholders' stock. You're repurchasing that stock. And by doing so, that stock becomes what we call treasury stock, as we talked about yesterday briefly. Now, there have been, on occasion, questions on the bar exam asked, can a shareholder be expelled? That's one of those bizarre questions because the concept of expulsion makes no sense in the context of a corporation. The way you would get rid of a shareholder, with a partner in a partnership, you can expel them. You kick them out, take their partnership interest away from them. In a corporation, a shareholder owns shares of stock. So the way you would, quote unquote, expel a shareholder is basically to buy back their stock. But you don't call that expulsion, so it's kind of a weird question to put in those terms. But the answer is that no, a corporation cannot expel, i.e., cannot force a shareholder to sell their shares back to the corporation, unless the corporation has retained in that stock a right of redemption, which never happens with respect to common stock. But occasionally corporations will issue another class of stock, of preferred stock, and will retain with respect to that stock the right to buy it back, the right to redeem that stock. So if you're a shareholder who owns nothing but preferred stock, and it is subject to a right of redemption, then yeah, the corporation could expel you, if you want to call it that. The corporation could exercise its right to redeem the stock by buying it back, and in effect leaving you without any equity rights in the corporation. But more typically, when we talk about the corporation taking back its stock, we're talking about repurchasing. We're not talking about a right of redemption. We're just talking about the corporation offering to buy back somebody's stock, and the somebody agrees to sell it for the price that the corporation offers. It's just a repurchase. But because it is a corporation taking the assets of the corporation and transferring them to the shareholders, in the case of dividends, the corporation gets nothing back for sending that money to the shareholders, whereas in a repurchase, the corporation gets its stock back, but still the cash of the corporation is flowing out to the shareholders. So we have to put the same limits on it that we do on the payment of dividends. A corporation may never repurchase or redeem its shares if it is insolvent, or if the payment made to get those shares back would render it insolvent. By the way, there's a typo there in paragraph 2 on page 17. It says action, in the second line, action would render it solvent. There should be a little in front of that solvent there. It's just a typographical error. So you cannot buy back stock if by paying for that stock the corporation's assets would be diminished to where the corporation is insolvent. The last sentence there in paragraph 2, scratch out. It's technically correct, but it relates back to all the technical rules I talked about with dividends that we deleted from the outline. That sentence should have also been deleted. It makes no sense unless you get into all that technical stuff. So just forget it. Again, a director who votes for the repurchase or redemption of stock improperly will be personally liable unless they relied on, bum accounting advice. And again, creditors of the corporation can sue the directors. Officers. Again, I emphasize, key point, it is only the officers of the corporation, the employees, who have the authority to act as agents of the corporation, to act with third parties. The directors on the board are merely legislators, just like a member of the U.S. Senate or House of Representatives can't go out and sign contracts on behalf of the government. They have a vote on management matters, but they have no individual personal authority to act for the corporation. Only the officers, that is to say the employees, can act for the corporation. What officers must there be? Well, there are three officers, or three offices, that must exist in every corporation by statute. You must have a president, you must have a secretary, and you must have a treasurer. And these positions are elected by the board of directors. You do not have to have any vice presidents. Corporations of substantial size usually have dozens of vice presidents, but none of them are required. And although you need three offices, president, secretary, and treasurer, you only have to have two human beings occupying those offices. So you can combine two of the three offices in a single person, but you have to have at least two people as officers. So if you are the sole shareholder of a corporation, and you're the only member of the board of directors, which is, you can have a one-person board, but you have to find somebody, if nothing more than basically your stooge, to occupy one of the three officer positions. The sole shareholder and sole director can be the president and treasurer, but you got to have another person be one of those three offices. Quite commonly, you'll have one person being the president and somebody else being the secretary treasurer of a very small corporation. Another point that has been asked quite frequently on the bar exam over the years: does the board have the power to remove an officer? And the answer is yes. And again, just like a director can be removed by the shareholders with or without cause, just because they're ugly, you can remove an officer with or without cause. And that is done by the board. Officers serve at the pleasure of the board of directors. They can be fired at any time and removed from their position. However, an officer may have an employment contract entitling them to be paid for a certain period of time. So that employment contract may still be valid. So if a president has a 2-year contract to be paid $100,000 a year for 2 years, and the board fires him after 1 year, he's still entitled to get paid that second year. It's kind of like football coaches. You know, if you fire them before their contract is up, they're entitled to be paid for the balance of the contract, but you still can fire them. An officer cannot go into court and get an injunction ordering the board to keep him as the president. So officers can be removed at any time by the board, but subject to whatever rights they then have in their employment contract. The authority of officers is First of all, if there's anything in the articles that specify what the officer's authority is or limits on officer's authority, then the articles are the ultimate determinant. Then the bylaws can define or limit an officer's authority. But most typically, the authority of the officers is described by the board in the employment resolution or employment contract. There is a peculiar little provision in the statute that says that the president of a corporation in Louisiana has the inherent authority to act on behalf of the corporation in legal proceedings in a variety of specified ways without getting board approval, unless the articles, bylaws, or board expressly deny that authority. So if there's nothing in the articles, bylaws, or employment contract saying otherwise, the president can agree to certain things during the course of litigation. I'm not sure what the original source of that provision is. It's a little unusual. It's not been tested, but it is there. But the authority of officers is dictated or determined by the board, typically, unless the articles or bylaws say something. And then they're supposedly limited by that. But remember, if somebody's hired as the vice president of purchasing, for example, but then their employment contract says, but you may not purchase automobiles. And the guy goes out and buys an automobile. The third party may believe that because he's the vice president of purchasing, that he has the authority to buy an automobile, because that's what people who purchase do, is they buy things. If the third party reasonably believes that, then the doctrine of apparent authority kicks in to bind the corporation, even though the officer exceeded his actual authority. He acted ultra vires, but apparent authority would bind the corporation, although the corporation could then turn around and sue the officer who exceeded his authority because he did act ultra vires. Shareholders. Again, a question that is not always, but I'd say 3/4 of the time, there's a question on the right to inspect the corporate books. The last 2 bar exams, there was a question that expressly asked this. Remember, in the partnership context, a partner always has the right to inspect the books of the partnership. Period, end of discussion. No exceptions, can't be taken away. The rule with respect to corporate shareholders is a little bit more complicated. For the first time, the last couple of bar exams have asked, first of all, when a shareholder has the right to inspect the books, what kind of records do they have the right to inspect? But that was a little bit of a cheesy question, but nonetheless they asked it. So the answer is the books and accounts showing the amounts of assets and liabilities, receipts and disbursements, gains and losses, records of the proceedings of the shareholders, directors, and committees of the board must be made available to the shareholders, but only shareholders who hold at least 5% of the outstanding shares and have owned those 5% for at least 6 months. So not every shareholder has the right to inspect the books. This is a rule that popped up back in the 60s when it was a practice of some dissidents, if you will, with social causes, who would go out and buy a single share of stock in some corporation and then demand to see the books. Or a journalist, some guy who writes for a newspaper, would go out and buy 1 share of stock and then go and demand to see the books of the corporation. So it was felt that we shouldn't subject corporations to this kind of harassment unless the shareholder has a significant investment in the corporation. And so these kinds of statutes were adopted in every state. In Louisiana, it's 5%, and you have to own that 5% for 6 months. unless you're a business competitor. Now, if the shareholder is a business competitor, then it kicks up to 25%. You have to own a fourth of the corporation before you can inspect the books. If you are associated with another company on its board of directors, a shareholder, or run your own business that competes with the corporation we're talking about, then you have to have 25% of the outstanding shares before you have the right to inspect the books. And it doesn't have to be a single shareholder. You can get a group of shareholders together who in the aggregate have owned 5%, or if one of them is a competitor, it kicks up to 25%. But you have to have at least 5% added, all the shareholders who together sign the petition or the request to see the books. So it doesn't have to be just a single shareholder, it can be a group of shareholders that aggregately own 5% for 6 months. The request to inspect must have a proper purpose. This is not hard to come up with. Again, you'd have to be a fool not to be able to state a proper purpose. I want to inspect the books to make sure my investment is being properly cared for. I want to inspect the books because I want to mail something out to the other shareholders related to an upcoming shareholder meeting, etc., etc. If you're a real idiot, you'll say, I want to inspect the books because I want to harass the corporation, or I want to do an expose for the New York Times. That's not a proper purpose, but you know, who's going to say that? But you do have to state what your purpose is, and it has to be a proper purpose. Once you meet the requirement, just like in the partnership context, you cannot take it right away from the shareholders. So the articles or bylaws cannot say shareholders of this corporation do not have a right to inspect the books. That's just invalid. The statute will not allow you to restrict the rights granted by the statute if you have 5% for 6 months. The articles or bylaws can make it easier for shareholders to see the books. You can lower the requirement to 3% or 1% or a single share. Or you can lower it from 6 months to 2 months or a week. So you can always make it easier for shareholders to obtain the right to inspect the books, but you cannot make it more difficult or restrict the right in any way. And one final thing before we take a break, dissenters' rights. In Louisiana, these are very limited. If you've studied the corporate law of another state, you may have spent a lot of time on dissenters' rights because they are much broader in most other states. In Louisiana, they are almost never relevant or invoked, and so they've not been asked about on the bar exams, but you should know what they are. Basically, what a dissenter's right is the right to force the corporation to buy back your stock if you're unhappy with something the corporation is doing. Now, in most states, the list of things that trigger your right to force the corporation to buy back your stock can be very broad. In Louisiana, it's very narrow. The only time that you can invoke dissenters' rights and force the corporation to buy back your stock is if less than 80% of the shares voted approved a liquidation of the assets of the corporation or to merge the corporation with another company. If less than 80% of the shareholders have voted to liquidate or merge, and you voted against it, then you can force the corporation to buy back your shares. But keep in mind that in order to vote to liquidate or merge, it requires 2/3 of the shares present at a meeting. So the only time this right could be triggered is if somewhere between 2/3 of those present, but less than 80% of the total shares, vote to liquidate or to merge. Now, liquidations and mergers are not very common in the first place, and then the rights are only triggered if you're between 2/3 and 80%. So it almost never happens in Louisiana, which is why I suspect it's hardly ever on the bar exam. In fact, I can't remember it ever being on the bar exam, but it's an important concept, so you should be aware of it. Okay, take another break. We'll come back at 5 after 11. Okay, everybody, let's crank it up and we'll be done for today. We're picking up on page 19. We've just got done talking about dissenters' rights, which I indicated have never been tested and which are unlikely to be tested because they're very narrow rights in Louisiana. At the opposite end of the spectrum are preemptive rights that shareholders have. These are almost always tested. In fact, in the last 10 exams, we know it's been asked about on 6 of them. And who knows how many of the others have had some question in the multiple choice questions. So this is something that they almost always ask about, preemptive rights. What are preemptive rights? That's quite frequently what is asked. Or they'll ask, when do shareholders enjoy preemptive rights? So those are the 2 questions we really have to answer. The first question, what are they? It's the right of a shareholder to purchase the same percentage of stock that the corporation is selling as they currently have of the existing outstanding voting shares. So if I currently own 30% of the shares of stock of a corporation, and the board decides to issue another 100 shares, I have the right, if I have preemptive rights, I would then have the right to buy 30 of those 100 newly issued shares, because I have the right to keep my percentage of the voting power. And that's the whole purpose of preemptive rights, to keep the board from diluting my voting power by issuing more shares to other people. So just as, you know, remember back yesterday, the board may not sell stock for less than fair market value because it is illegal to dilute the value of existing shares. It's always illegal to dilute the value of existing shares. Not so with respect to the voting power of existing shares. If we don't have preemptive rights, which in most cases corporations don't have them, let's say I have 300 shares in a corporation that has 1,000 shares. I have 30%. If the board wants to issue another 1,000 shares and sell them to somebody else, suddenly my 300 shares is 300 out of 2,000. And I only have 15% of the voting power. My voting power has been diluted. And it may well be that that will make me unable to block certain things that 30% might be able to block, but that 15% wouldn't be able to block. So in order to protect shareholders from having their voting power diluted, the articles can provide that the shareholders hold preemptive rights. So that answers both questions. Number one, what are they? They're the right of shareholders to purchase the same percentage of newly issued shares as they currently hold of existing voting shares. And how do you get preemptive rights? There must be a provision in the articles expressly providing for it. If the articles are silent, there are no preemptive rights. Those 2 questions are asked over and over and over in the bar exam, so you need to know them. They don't go into much detail on preemptive rights, so the discussion down there in little letter C have not been asked, but you should whip through them fairly quickly so you get a sense. Because if all the articles say is preemptive rights exist, and they don't explain that, then preemptive rights do not apply to shares that are issued for consideration other than cash. So if I've got 1,000 shares, I've got 300 out of 1,000 shares, and the board wants to dilute my voting power, they can issue another 1,000 shares, and I can say, wait, I have the right to buy 300 of those shares. No, 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 we're issuing those 1,000 shares in exchange for goats. that are worth 1,000 shares. Well, they're issuing that stock for something other than cash. The preemptive rights don't apply. Likewise, if somebody has the right to convert bonds that they've bought, corporate bonds, sometimes bonds have attached to them the right to convert those bonds into shares. If the bondholder exercises that right, your preemptive rights don't apply. Treasury shares don't count unless you expressly say so in your articles, which you probably should do. Otherwise, the board can issue another bunch of shares of treasury stock as opposed to newly issued stock. So you would have to say preemptive rights apply, and they apply to the issuance of treasury stock as well as newly issued stock. And likewise, compensation under an employment contract doesn't count. So if you're going to have preemptive rights, you not only need to say shareholders have preemptive rights, but you need to be specific that they apply even in some of these other cases that you want them to apply to. Shareholder meetings. There are two general types of shareholder meetings. One are annual meetings. These are the regular meetings that are supposed to be held every year. The only thing that absolutely has to be done at an annual meeting is to elect directors. But as I said, Louisiana is unique in not requiring that at least one director be up for election every year. So there may be a year in which no director's term expires, and the corporation doesn't bother to hold a shareholder meeting. Can't do that in any other state, but in Louisiana you can. And if the corporation does not hold a regular shareholder meeting, an annual meeting, then there is a provision mentioned at the top of page 20 where a shareholder can petition the secretary of the corporation and require the corporation to hold a shareholder meeting if there has not been one held for 18 months. This provision, again, is unique to Louisiana, but it's unique to Louisiana because we're the only state where you can actually go a year without having an annual meeting. So you need this provision. The corporation cannot just routinely ignore having annual meetings without giving shareholders the right to force them to hold one. But you have to go 18 months without an annual meeting, and then the shareholder has the right to force an annual meeting to be called. And the meetings can be held anywhere. They don't have to be in Louisiana. You can hold them anywhere, and that can become an issue if you want some shareholders not to attend. You hold the meeting at a place where they're unlikely to go. But you can do that. The other kind of meeting other than the annual meeting is a special meeting. And as we've mentioned before, special meetings can be called by the board of directors, the president of the corporation. Again, this is a provision unique to Louisiana. Most states do not say that the president can call a special meeting. But our statute specifically provides that the president has the power to call a special meeting, or by shareholders holding at least 20% of the voting shares. Now, if you own more than 20%, or if you own 20% or more, you by yourself can call a special meeting because you hold 20% of the voting shares. Otherwise, you have to get a group who collectively own 20% of the voting shares. Again, the articles may make it easier to call a special meeting, but you can't make it harder. In other words, you can't say it takes 40% of the shareholders. And you can't say the president doesn't have the right to call a meeting. But you can make it easier to call a special meeting. You can say the president or the secretary has the right. Or you can say that 10% of the shares have the right. Again, make it easier but not harder, just like inspecting the books. You can make it easier to inspect the books, but not harder. There must be written notice of a meeting stating the specific matters to be voted on. And that notice must be sent to all shareholders not less than 10 nor more than 60 days. So you got a 50-day window from the time the notice is sent within which the meeting must be held. And once the meeting is convened, like at 5 o'clock in the afternoon, you can adjourn it and start up the next morning. You don't have to give notice of the meeting of the next morning because it's the same meeting that's just been adjourned and started after a break. There was a question that was asked for a couple of bar exams about 10 years ago that I thought was really kind of unfair, but what are you going to do? The question asked, can you have shareholder meetings by telephone conference call? And in corporations where you only have a handful of shareholders, that's technically very feasible. The question is it permitted under the statute? Well, the reason I thought it was an unfair question is because the statute is silent. It doesn't say whether or not telephone conference calls constitute a valid meeting. So we don't know the answer. I put in the model answers back then that I believe that since the statute expressly says that you can have board of director meetings by telephone conference, but is silent with respect to shareholder meetings, that the negative implication is that since they don't expressly provide for it in one case but do in the other, that shareholders cannot have telephone conference meetings. Which would seem kind of silly, but if in fact you interpret the statute in the way normal rules of statutory interpretation are applied, that would be the result. So we think that you can't hold telephone conference meetings, but we're not sure. Happily, they haven't asked that now for several years, but they did back a while ago. Again, you're supposed to have a meeting. Shareholders take action at shareholder meetings. But like the board of directors, there is an exception. Shareholders can take action without a meeting with unanimous written consent again, if all the shareholders agree in writing to the action. So like the board, unanimous written consent does away with the requirement that there be a meeting. But unlike the board exception, there is an exception to the exception for shareholders. If the articles have a provision saying so, and again, if the articles are silent, then unanimous written consent is the only exception to the meeting requirement. But you can include in your articles a provision that allow for less than unanimous shareholder written consent. But if you do, then the number of shares that have to be represented in favor of the resolution must be the percentage of shares required in the articles or bylaws to pass that type of resolution. So what that means is if you're voting to amend the articles, well, the statute says you have to have 2/3 of the votes present at a meeting to amend the articles. If your articles have a provision saying less than unanimous written consent is okay for a shareholder action, then in order to amend the articles without a meeting, you would need at least 2/3 of all of the shares, because that's what the statute says you would need at a meeting, even though it's 2/3 of the shares present at the meeting, for unanimous written consent, it's 2/3 of all the shares because we assume that everybody's at the fictitious meeting, if you will. I hope that makes sense. But the default rule is that the only exception to the meeting requirement is unanimous written consent. The person who is entitled to vote the shares is the person of record on a specified date prior to the meeting. Because the secretary needs to know who has the right to vote the shares, there has to be a closing of the voting rolls, so to speak, on some date prior to the meeting. So usually a week or 10 days prior to the meeting, the secretary closes the rolls. So if a shareholder sells her shares within a few days of the meeting, the person who buys those shares doesn't have the right to vote them at the meeting, unless they get a proxy, and we'll talk about that when we talk about proxies. But the person holding the right to vote is the person who is of record as owning the shares at some date prior to the actual meeting. Quorum. Back to this really riveting stuff again. But again, they ask about it a lot, so remember it. And by the way, at the end of the corporation's outline, there is a section, I think it's on pages 31 through 33 of the outline, that just summarizes the quorum and voting requirements for both board meetings and shareholder meetings. That's not new material, it's just a compiling of quorum and voting requirements to make it a little easier for you to study it. But anyway, that's where it is. The quorum for shareholder meetings. There must be a majority of the total voting power represented at the meeting. And what that means is there must be enough human beings in the room holding the right to vote at least a majority of the outstanding voting shares. Might be one person. One person might own enough shares or hold enough proxy votes for enough shares to constitute a majority. If one person has the right to vote a majority of the shares, then you can have a meeting with that one person. So unlike the board of directors, where you actually have to have a number of bodies in the room, you have to have a majority of the human bodies in the room. The shareholder meetings, you're not counting bodies, you're counting shares. And you have to have enough people who hold a majority of the voting shares. The quorum may be changed in the articles or the bylaws, but you can't lower it to less than 1/4. Keep in mind that treasury shares and unissued shares, that is to say shares owned by the corporation itself, are not voting shares because they're not outstanding. Likewise, shares owned by a subsidiary of the corporation are outstanding. Somebody does own them, but they still may not be voted because the corporation owns the owner of those shares. It's a subsidiary. Now, once the meeting is validly convened, just like board meetings, if you have a quorum at the start, business may continue to be conducted until adjournment, even if some shareholders leave so that there's less than a majority of the shares in the room. The little wrinkle here is that if you remember back to board meetings, When board members leave so that there is less than a quorum, they can take action, but only if a majority of the quorum votes in favor of it. That little provision is not in the statute with respect to shareholder meetings, which means that once the shareholder meeting starts with a quorum and some shares leave, the voting standard for adopting resolutions remains a majority of the votes cast. So if I've got a corporation with 1,000 shares of stock, in order to convene a meeting, 501 of those shares have to be present or represented in the room to start the meeting. So 501 shares show up. If somebody holding 500 of those 501 shares leaves so that one guy with one share of stock is left, he can do anything he wants. Because that one vote is the only vote that will be cast, and it will be a majority of the votes cast. That's rather bizarre, but that's what the implication of the statute is. In the board case, you got to have a majority of the quorum if less than a quorum is present. In the shareholder context, the statute does not say that. Top of page 21. One share, one vote is the default rule. You can change it, but the bar exam never asks about that. You can give different shareholders different voting power, but then again, you'd have to have multiple classes of stock, because the rule is that all of the shares of the same class of stock have to have identical rights and privileges in order to give one shareholder more voting power per share. You'd have to have a separate class of stock. It almost never happens. If you want somebody to have more voting power, you give them more stock. You don't give them a stock that has greater clout. So every share has one vote. Again, treasury shares, unissued shares, and shares owned by a subsidiary don't count. They don't have the right to vote. And by the way, the definition of a subsidiary, probably should have said it down below as well, is if more than 50% of the stock of another corporation is owned by your corporation, then that corporation is a subsidiary, because you have more than a majority of the shares of stock in that corporation. We consider it a subsidiary, and therefore if that subsidiary owns stock in the parent corporation, that stock may not be voted. The voting standard, as I just mentioned a few seconds ago, is that for most things, it's a majority of the votes actually cast. And I put that in italics and bold there to remind you that that's different than a majority of the votes present. If the standard is a majority or 2/3 or whatever percentage of the votes present, like at board meetings, then an abstention is a no vote, because everybody in the room counts in the denominator. In this case, it's a majority of the votes actually cast. So there can be people in the room who abstain. And if they abstain, they don't count one way or the other. So again, if you have 100 people, 100 shares in the room, and the vote is 1-0 with 99 abstaining, it passes, because a majority of those voting voted yes. Now, there are certain things that have a different voting standard than a majority of the votes actually cast. I'm repeating myself here because we've already talked about it, but amending the articles requires 2/3 of the voting power present. Not cast, present. So it requires 2/3 of the shares in the room. And abstentions are no votes. Authorizing mergers is the same. 2/3 of the voting power present. Liquidations, 2/3 of the voting power present. Dissolution is only a majority of the voting power present. The other thing that shareholders vote on that requires something other than a majority of the votes actually cast is the election of directors. If the articles are silent, the method of electing directors is what we call straight voting, which has nothing to do with sexual preference. It has to do with the fact that every director's seat is a separate election. It's like voting for members of Congress or state legislature. Every seat is its own separate election, and candidates run for a particular seat. And all of the candidates for each seat are on a ballot, and each share gets to cast one vote for whoever the shareholder wants to win that seat. And when all the votes are counted, whoever has more votes than anybody else gets the seat. Doesn't require a majority, whoever has more votes. So if there's 10 people running for a particular seat, in theory, somebody with 11% of the vote could win. If the other 9 people split the other 89% equally, the guy with just a little more than 10% would have more votes than anybody else and would win the seat. Does not require a majority, just a plurality. There is an alternate way of electing directors called cumulative voting. And this sounds a lot more complicated than it in fact is. There is almost always, not almost always, I'd say 2/3, 3/4 of the time, there's some question on the bar exam about cumulative voting. But it's usually a pretty basic, big picture kind of question, like, what is cumulative voting? And so you have to kind of be prepared with a canned 2 or 3 sentence description of what cumulative voting is. Or there'll be a question is, how does a corporation have cumulative voting? Well, you have to state that it has to be provided for in the articles. Can't have it in the bylaws or anywhere else. Has to be a statement in the articles that directors of this corporation will be elected by cumulative voting. But there have occasionally been questions that don't really ask you to discuss the mathematics of cumulative voting, but at least have some basic description of how it works. So here's how it works. The idea is that if you want to start a corporation and you want somebody or some group to buy a minority interest in the shares, so you're going to hold 60% of the shares and you want your partner or partners to own, and I use the term partner not in the technical sense, but in the generic sense. You want the minority shareholders to own 40%. If you have straight voting for directors, the 60% owner will elect every director because every seat is a separate election. And so this guy with 60% can elect every director because every election will come out at least 60 to 40. But the 40%, the people that he wants to be minority shareholders, might say, well, wait, I'm not going to invest 40% of the capitalization of this company unless I can have at least a seat on the board of directors. And so what you do is you create cumulative voting, which is a method by which all the directors up for election at a given time are on the same ballot. So instead of each seat being a separate election, all the seats cumulatively are a single election. And then each share of stock gets to vote the number of times as there are seats up for election. So if there are 3 seats up for election, each share of stock gets to cast 3 ballots. And you can accumulate those votes. So you can cast all 3 of them for the same candidate. And if you think that through, the mathematics basically means that with a certain percentage of less than half the votes, you can always be guaranteed to elect at least 1 director. Now, what percentage do you need? Well, the percentage you need is essentially you take the total number of directors to be elected and you add 1. And that's the denominator. So if there are 3 seats up for election, how many shares do you need to be guaranteed to elect 1 director? And the answer is 1 over the denominator. So if there are 3 seats up for election, you need 1/4. Actually, you need 1 vote more than 1/4, because with 1/4, you're only guaranteed of a tie. So if you have 3 seats up for election and you have cumulative voting, the number of shares you would need would be 1/4. If there are 95 seats up for election, you would need 1/96 plus 1. If there are 1 million up for election, you would need 1 over 1,000,001 plus 1. And then you'd be guaranteed that if you accumulate all your votes for the same candidate, that candidate mathematically cannot be surpassed by all of the other candidates, so that you're guaranteed to have at least 1 seat. Just as a side matter, much like preemptive rights, there are easy ways for the majority owner to get around cumulative voting. So for example, if you've got a board with 3 directors, then a minority shareholder who owns more than 25% of the shares could elect a director, right? Well, all you'd have to do is stagger the board terms, so that instead of all 3 coming up for election every year, you'd only have 1 coming up each year. And if only 1 comes up each year, then there's nothing to accumulate. So you've effectively defeated the effective cumulative voting. Likewise, you can increase or you can decrease the size of the board so that there are only 2 directors up for election at any given time, in which case you would need 1/3 of the shares in order to elect a director. So there are ways that you can play games, and of course ultimately a majority shareholder who owns 2/3 of the shares could amend the articles and eliminate cumulative voting, unless you put in your articles that there's cumulative voting and this provision can only be amended by a unanimous vote of the shareholders. So if you're going to have cumulative voting, you have to devise it very carefully in your articles to make sure that all of the tricky devices that the majority can use to dilute or get rid of it are not available or effective. Fractional shares cannot be voted. Okay, proxies. Remember, with directors, there's no proxy voting. unless the articles have that peculiar provision that allows a director to give a proxy to another director or a shareholder. But the general default rule is no proxy voting for directors. Completely opposite for shareholders. We assume shareholders will give proxies for most corporations. Now, the kinds of corporations you get on the bar exam are usually ones where there's 2, 3, 4 shareholders. And there you usually don't get proxies. But if you have a corporation where there are a number of shareholders, invariably shareholders are going to give their proxies to somebody else for shareholder meetings. And it's quite common that that happens. The proxy, by the way, can be as broad or as narrow as the shareholder wants it to be. You can give somebody a proxy to vote however the proxy holder wants. Or you can give somebody a proxy to vote on a particular issue the way the shareholder dictates. So I hereby give my proxy to Sally, and she has to vote for George for director. Or she has to vote in favor of the pension plan that is being proposed. So you can direct the proxy holder how to vote on particular issues, or you can just give the proxy and say, vote however you want. But you are giving the right to cast the votes of the shares you own to somebody else with any directions you may choose to give them. A proxy must be in writing. It must be filed with the corporate secretary, again, so the secretary knows who has the right to vote. Somebody walks in the meeting and says, hey, I've got the right to vote Joe's shares. How does the secretary know that unless she's been given a proxy in writing saying that Joe has the right to vote the shares? Proxies are normally revocable at the will of the shareholder. So if I give you a proxy, I can take it back. And I can revoke it in any one of a number of ways. I can die. I can issue a written revocation delivered to the corporate secretary. I can show up at the meeting myself, in which case I have the right to cast my shares and the guy with the proxy is pushed to the side. I can give somebody else my proxy, and the more recent trumps the older. So I can revoke any time I want. However, there is a way to make a proxy irrevocable so that I can't take it back. I can't revoke it. But the law says that you can only make a proxy irrevocable if it is, quote, coupled with an interest, unquote. That is a vague concept, and we're not sure of all the possible things that might give the proxy holder enough of an interest in the corporation to allow me to make my proxy to him irrevocable. But there are some things we know constitute a sufficient interest so that I can make the proxy irrevocable. Now, the first thing, the written statement creating the proxy must say it's irrevocable. If it doesn't say it's irrevocable, then it's not. It can be revoked at any time. If it says it's irrevocable, then it is still only irrevocable if it is coupled with an interest. And what are the kinds of interests? Well, we know. One we've talked about a little while ago. If I sell my stock to you after the record closing date for the meeting, the secretary still thinks I have the right to vote those shares, even though I've sold the shares to you. If you buy shares from somebody after the closing date for the meeting, You want that seller to give you not only the shares, but an irrevocable proxy so that you can vote the shares you own, because you have an interest that is sufficient to trigger the right to receive an irrevocable proxy. Likewise, a creditor of a shareholder can take the shares as collateral on a loan. And if I lend you money and I take back your shares in a corporation as collateral, a security interest in them, in other words, I can ask that as part of that collateral, you give me an irrevocable proxy to vote those shares until you pay the debt off. That we know is sufficient to allow for an irrevocable proxy. And the third example is one we'll talk about later. If I have a shareholder vote pooling agreement where we have an agreement to vote our shares together, oftentimes the only way that we can enforce that agreement is if we give the right to vote our shares to some third party, because otherwise we might agree to vote them together and then we renege. So the only way to make sure we don't renege is to give our shares, the right to vote our shares, to some third party. And if we do that, we can give that third party an irrevocable proxy. So those are three examples of the kinds of interests that a proxy holder can have that allows us to give them a proxy that we cannot revoke. A proxy is typically valid for 11 months unless the proxy document creates a different period of time. So the default rule is that a proxy is valid for 11 months, but the proxy instrument, the document that creates the proxy, can change that date. However, it cannot be greater than 3 years. You can give somebody a proxy for a specific meeting. You can give them a proxy to vote at all meetings for the next 3 years, but you can't give it for more than 3 years. The proxy automatically has to expire after 3 years regardless of what it says. But the default rule is it's only valid for 11 months. Shareholder arrangements, voting trusts. There have been several questions. Again, I think 4 times in the last 10 exams, we know there have been questions on voting trusts. So less than half, but quite frequently, there's a question about a voting trust. A voting trust is, like its name suggests, a trust created by one or more shareholders who takes her shares and donates them to a trust. The ownership of those shares then devolves to a trustee, the trustee of that trust. And the trustee has all of the rights of ownership. The right to vote the shares at meetings, the right to call for a special meeting, to sign a petition to call for a special meeting, the right to inspect the books. All the rights that a shareholder has now belongs to the trustee. Except that all of the financial benefit from the trust is invariably given to someone else. So, for example, if you have minor children, or you have idiot children, and you don't want them to control the shares, you don't want them to have the right to vote or to do any of the things that shareholders normally do, but you want them to get all the benefit of the shares. You want them to receive the dividends, and you want them, if the shares are sold, to receive the proceeds. You create a voting trust whereby you give somebody who you do trust the trustee's position, but all the financial benefits flow to the beneficial owner of the trust. A voting trust is valid for 15 years, or any other period stated in the trust agreement that does not exceed 15 years. So you can create a voting trust for 5 years or 10 years or 15 years, but not more than 15 years. The trust agreement may have a clause in it that allows the creator or creators of the trust, the original shareholder, to extend that voting trust for up to an additional 10-year period from the time the extension is approved. So you can have a 15-year voting trust with this clause allowing for a 10-year extension. Of course, in the first 5 years, it would make no sense to extend it because 10 years from the date of the extension would still be less than the 15 years of the trust. But in the 14th year of the trust, the creator may vote then to extend by up to 10 years, which would then make it a 24-year trust, because you're 14 years. You extend 10 years beyond that 14th year. And a voting trust is a public document. It's a trust agreement. It has to be filed with the secretary of the corporation. It has to be subject to shareholder inspection. You can't keep it a secret because it is a formally created trust agreement. Okay, let's call it quits. We'll pick up tomorrow with vote pooling agreements.